so that the international media could focus on the CA protest that was going on across the country. And the CA protest, which they called it as a peaceful protest, can be used as a catalyst to portray the crime, to portray that in India the atrocities that are being done against the minorities. So that was the motive, and the major point that the Delhi police have highlighted to the Delhi High Court as well as a trial court and in the Supreme Court as well, when in the month of December, when the hearing was going on, the Supreme Court was hearing all the parties throughout. At that particular time, the Delhi police have also told the court that these particular accused were trying for a regime change. So this major point has been highlighted time and again by the Delhi police in their investigations.
In fact, we have some big words coming in straight from the courtroom, and Sabyasachi, thank you so much for giving us all of those informations. I'll request you to please stay on with us, continue tracking some more updates coming in as far as this big case is concerned. I am being joined by Advocate of Supreme Court Sanjay Chadda and also former DGP of Uttar Pradesh Ranjan Dwivedi, both here with us on News 9. Thank you so much, gentlemen, for joining us and speaking to News 9. Sanjay ji, let me first come to you, sir. I want to understand from you, as somebody who comes from the legal arena, an expert's view of to what extent can prolonged incarceration without trial influence bail decision in such UAPA cases?
Well, two, three very important points which are very crucial today. One is UAPA, the Unlawful Activities Prevention Act. It is a special act. We have to consider it in our mind before any thing happens. Second is the question vis-a-vis civil liberty of an individual, which is also very crucial today. So we have to see how the element of delay in trial, how the element of non-finding of any case, that is important, how the element of his not being present at all the 553 FIRs, he is not in town, he is not in Delhi, he is somewhere else. So these are also crucial matters. Now, very rightly, you have said that the evidences, the speeches which were produced before both the courts below, that is District Court as well as the Delhi High Court, both the places, they have placed, the Delhi police, the prosecution has placed various such evidences which are very crucial, which in totality are taking into one point, that is that these speeches, these WhatsApp messages, WhatsApp groups have led to this heinous crime, that is the riots in the northern part of the Delhi. So these are the very crucial points which I feel we have seen that in the previous two orders, both the courts below have taken into consideration, and based upon that, the courts have gone to the extent and they have stated that, look, there is very, very serious element to it. Unlawful Activities Prevention Act, that is we call it UAPA, that is also very important. The bail is otherwise the bail is rule and jail is exception, but here this law specifically provides no, it is not. If there is a chance that because of your unlawful activities there is a chance of national security, there is a where we are seeing that there is a harm to the national security, etc., etc., and it is going to lead to some riots, some disturbing things are happening, then bail is not to be given. That is what it is, not as a matter of right or so trial has not become. That is the very crucial element. Number one, I think they have made the bail application only on 3 counts. One is trial, delay in trial. Second, there is no relevant what you call case
Mr.
made out
Chadha, Mr.
against them.
Chadha, my apologies for interrupting you over there. I've got a big breaking news coming in right now at our bulletins that bail has now been denied to Sharjeel Imam. A big breaking news, ladies and gentlemen. Those who have just joined us, a very crucial hearing of a case related to 2020 Delhi riots case is going on at the moment in the Apex court. We have got a big word coming in that the provisions of UAPA cannot be ignored in this case, and hence the bail has been denied to the Delhi riot case accused Sharjeel Imam. Going first to my reporter Sabyasachi Roy Chaudhary, who continues to stay with us here on the broadcast. Sabyasachi, over to you. The big word coming in straight from the courtroom. Sabyasachi, am I audible to you? Can you hear me? Can you provide us more details?
By the Supreme Court. Well, that's right, Sakshi. Sharjeel Imam bail application has been rejected by the Supreme Court. And Sakshi, what is important to note that the Supreme Court has said that these cases are under special law, which was passed by Parliament, which have strict bail condition, especially when national security is involved. The law also covers acts that disrupt essential services or harm the economy, not just killing or physical damage. And the Supreme Court has noted that Umar Khalid and Sharjeel Imam are differently placed from the other accused because there is specific evidence suggesting that they are the main conspirators, and therefore the court had held the bail cannot be granted only because of delay or prolonged imprisonment. So clearly, Sakshi, the Supreme Court rejecting the bail application of Umar Khalid and Sharjeel Imam. And what is important to note that the court, the Supreme Court, the Apex Court have noted that there are enough evidences that they have to prove that Umar Khalid and Sharjeel Imam are the main conspirators as far as the Delhi riots is concerned. And in the investigation of the Delhi by the Delhi police itself, they have enough evidences, whether it is the video footages of all the communal speeches that has been given by Umar Khalid or Sharjeel Imam, and also the digital evidences that they have collected from different WhatsApp group, and also in one of the speech where Sharjeel Imam clearly pointing out that there are attempts to block the chicken neck, clearly shows that there are attempts to destabilize the country, there are attempts to change the present government. So based on these evidences that the Delhi police have collected, we had seen earlier the trial court as well as the Delhi High Court rejecting the bail application of all the accused. Now the Supreme Court coming up with a very important observations that the UAPA under which these accused are in jail for a very long time, the trial has not begun, but that solely cannot be a base on which they would be the court can be granting them bail. In fact, the Supreme Court also understood that how these people were the main conspirators, how they mobilized people across the country, and they in fact wanted to carry out a pan-India protest like we had seen in the national capital, where 53 people have lost their life, over 700 people were injured. So clearly the Supreme Court clearly stating that when you talk about the UAPA is a special law which has been formed by the Parliament when it comes to national security, and under these circumstances, when the issue is related to the national security, bail cannot be granted. Back to you, Sakshi.
Absolutely. Sabyasachi, let me quickly take a question with Mr. Dwivedi. Also has been waiting patiently here on the broadcast with us, sir. With this verdict now coming out, can we say that the court has clearly drawn a line between dissent and conspiracy?
Yeah, actually, the court is obviously the Supreme Court, and it's what it says is law. And it's good it's been clarified, because I'm sure the impact of this judgment would also be there in several other cases. And, what's important to understand in this is national interest is supreme. There is no other interest that can be above national interest. And the timing of this incident, the timing of this riot, when the US president is here, which is an important visit in the most important country in the world, the president is here, and so much national interest is involved, it's as if you're putting the CAA interest above national interest. So, all this probably must have been considered. And it's very fortunate. It's very fortunate for the law enforcement agencies that this very clear judgment of the Honorable Supreme Court has been delivered, which will assist other courts in deciding matters when they come up where national interest has been compromised.
Absolutely. And Mr. Chadha, my apologies for interrupting you over there because we got the big verdict coming out straight from the courtroom. Now I want your opinion on this case. What do you have to, say about the verdict?
Well, as I said earlier also, that it is a special act. As Dwivedi ji has said, national security is paramount. It's prime. It's the first thing to be looked after. And as the judgment has come from Supreme Court, now this is the law of the land. It is a special act. UAPA is a special act under which they will not accept any kind of delay in trial is not the ground. That's what very specifically the court has said. Not only that, as I said, national security is given the topmost priority. Their own act, their own speeches, their own WhatsApp content, the digital content which they have created is causing and taking everybody to one point, that is that they are the root cause. They're the accusation, the offense which is made out to them is very clear, and it is specifically on the points that they have created an environment which has led to these riots, and they are the prime accused in it.
Right. Mr. Chadha, this, almost reminds me of that stringent Watali order. Don't you think this has now been reaffirmed by the Honorable Court?
Wonderful. This has been reaffirmed, number one. Number two, now this is the law of the land. Everybody has to follow it. These courts, the lower courts have to follow it. I just say one more line here, that the Honorable High Court of Delhi and the lower court has given a detailed version as to what all are the aspects which are covered in these evidences. What are the video of clipping, as we have said, the speeches in that. Whatever is covered, they have made that part of the order also, that these are the lines have been chicken neck.
Yes.
There are 4 or 5 things which they have talked about. One is they want to separate Assam from India, which is a bigger conspiracy, I must say.
Mr. Chadha, my apologies. We are cutting across to some live visuals coming in of Ashwini Kumar. Let's take a look at that first.
Most unhappy because Sharjeel Imam and Umar Khalid have been in jail for a very long time, and the Supreme Court's own judgments say that long incarceration itself should be a consideration for the grant of bail. After all, there is no recompense for liberty once lost.
So that was Ashwini Kumar, advocate, speaking about the decision which has been given by the Apex Court. He is also the former law minister. Now, Sanjay Chadha ji, let me come back to you. You heard what the man has to say. Your opinion on that?
That is what I am saying since the discussion has started.
Yeah.
It is a special act.
Yes.
That law is there. That is the law of the land. That you can't keep a person without starting the trial for years together. That is there. That is the law. But in cases where there is a special act, where there is a special provision, this act is made for this particular reason only. That this is in special circumstances where specific offenses which are against the nation, which are against the nation's securities, India's security. So that is the reason this law has been made. And I feel as per this law, this judgment today's order is as per the law only.
Absolutely. Mr. Chadha, I request you to please stay with me and also Mr. Dwivedi, please stay with me. Let me quickly go to my reporter Sabyasachi, who's been waiting patiently. Sabyasachi, some big decisions have been taken. Some of them have been given bail, but with some conditions. Would you like to highlight all of those things?
We'll shortly get to know about the conditions of the other 5 accused in the case who have been granted bail. But Sakshi, it is also important to note that while the hearing was going on in the Supreme Court and the Supreme Court had reserved its order in the month of December, at that particular time, the lawyers, whether it is Mr. Kapil Sibal or Mr. Singhvi, who was representing Umar Khalid and Sharjeel Imam, in fact, they have made a point in front of the Supreme Court that the Delhi police did not speak about the change of regime in the lower court or in the trial court or in the Delhi High Court, and suddenly the Delhi police spoke about the regime change here in the Supreme Court. Now, they were highlighting the fact that they have been in pre-trial detention for a long time, for over 5 years, and that is the reason why bail should be granted to them. In fact, they have also spoken about Article 21, where they have spoken about the right to liberty. But all these things today have been clarified by the Supreme Court, where the Supreme Court clearly pointing out that a pre-trial detention does not mean that it is equal to punishment. And the Supreme Court clearly have put the national security at the highest level, and clearly highlighting the UAPA Act under which the cases have been registered, that this particular act have been formed by the Parliament when it comes to national security. And under these circumstances, both Umar Khalid as well as Sharjeel Imam cannot be granted bail. In fact, the Supreme Court also have acknowledged that there are enough evidences which is against them, which has been collected by the Delhi police, whether it is regarding different speeches that has been given by them or different digital evidences that the Delhi police have collected in the case. So clearly, when you have the trial court as well as the Delhi High Court rejecting the bail, and the Supreme Court began today by saying that they accept the rejecting of the bail which has been given by the Delhi High Court today. Sakshi.
Right, Sabyasachi, let me go back to Mr. Dwivedi. Mr. Dwivedi, I also want your opinion on the verdict, sir. Now, 5 have been given bail, and the apex court, the Honorable Court, has said that this should not be considered as the dilution of allegations in this particular matter, and that Umar Khalid and Sharjeel Imam have been named as the main conspirators.
Yes, Madam, as I said, Supreme Court is the apex court, and what it says becomes a law. And I'd just like, so there's no question of giving any opinion on what the Honorable Court has said, but I'd just like to highlight here that you see the democratic status of India, that every person has a right to approach the highest court, and the highest court is not affected by any considerations which are away from the main evidence and law in the matter, and which shows that 5 people have been given bail, which shows the fairness of our courts, the openness of our courts, the secular nature of our courts, and it should be lauded. And I'm very happy that this kind of a judgment has been given, which is a balanced judgment as from the information we have till now, and identifying the core people who instigated the whole thing and denying them bail also shows how national interest, national security should be kept highest. And mind you, 53 people died. After all, they also have some kind of a human right. It's not just a human right of somebody who's an accused and incarcerated. So the judgment is a very good judgment, in my opinion. And you can't give any opinion on what the Honorable Supreme Court says, but it's a good judgment in the sense that now there's very clear directions for the lower courts, for the High Court, to adjudicate on such matters.
Right. Mr. Chadda, what kind of precedents, according to you, will now be set for the lower courts as far as the UAPA cases are concerned, and also to the citizen of this country as far as raising dissent, doing the protest, coming out on streets are concerned?
Well, 2 things. One, we must understand this, that the order passed by the Supreme Court, the apex court, are the law of the land. Today, this is the law of the land, number 1. Number 2, as far as the relationship between protest and to what extent you can protest, to what extent you can speak, there is a fundamental right which is paramount, which is the most important fundamental right, Article 19(1)(a), which is freedom of speech and expression. This is the one of the top-notch right. If we go through the democracy, we are the biggest democracy of this country, is this world. So where Article 19(1)(a) is paramount, no doubt about it. But there are reasonable restrictions also. So national security is one of the reasonable restrictions imposed by the constitution makers. It is not an absolute right. We must understand this. It is not an absolute right. So these kind of restrictions are there. Now, this is the law. Law says that you cannot go beyond certain limit in expressing your interest, in expressing your views. Like today, we two are sitting in this television debate. I have restriction. I can't use derogatory language against anybody. Against you, I can't. So these are the restrictions, and these are the fundamental of a society also. But coming to the criminal part, which is the question today before us. So Article 19(1)(a) guarantees the freedom of speech and expression with restrictions, reasonable restrictions. These restrictions are reasonable restrictions. These are not that you go and do whatever you want to do. So before protesting, now the message to the masses, message to everyone, to me, to you, to all our viewers is, when you are speaking, please see whatever you are speaking is within the ambit of law. You can't talk something which is anti-national. Talk in the sense anti-national. Constructive criticism is absolutely welcome, I'm telling you. If the media where you are sitting, you are one of the pillars of this democracy, I must say. So if you will not criticize the government, the government, the current setup is not criticized by media, it is not good for democracy. So constructive criticism that this should have been done instead of this is welcome. But saying that you will part away, chop the country, is this constructive criticism? Not covered within the limit of reasonable restrictions as stated in the constitution. You can't talk like that we will chop off the part of the country. Assam will be taken away. CIA law is not correct. All those things. Yes, you can criticize CA. You can criticize any law. You can criticize any policy of the government. But you can't talk something beyond, like you cannot, टुकड़े नहीं कर सकते.
Absolutely. And another statement, another slogan, which was also about the judicial killing with regards to the Afzal Guru, the decision that the apex court took then, and calling it a judicial killing and also doing the contempt of court. Sabyasachi has been patiently waiting. Sabyasachi, we are getting continuous updates coming in straight from the courtroom. It's trickling in and we are flashing it for the betterment of our viewers as well. For those who have just joined us, please walk us through, the nitty-gritties, the big details, the big updates coming in as far as this case is concerned.
Sakshi, the Supreme Court, the Apex Court, has directed that the trial court should ensure that the examination of protected witnesses and proceeds without delay, and that the trial is not unnecessarily prolonged. Now, the court has found that based on the prosecution's material, the charges against Umar Khalid and Sharjeel Imam are prima facie established, and they stand on a different footing from the other accused, and the statutory restrictions on bail apply to them. At this stage, granting bail was held to be inappropriate. Now, the case was under the special law which was passed by Parliament, which imposed strict conditions on bail, especially in matters affecting national security. And
hold on, Sabyasachi, please hold on. Let's quickly get some live visuals coming in straight from the ground. I'll come back to you.
जल्दी चलना चाहिए, और अगर एक साल में सारे प्रोटेक्टेड विटनेस जो होते हैं, अगर वो उनका एग्जामिनेशन खत्म नहीं हुआ, तो एक साल बाद उमर खालिद और शर्जील इमाम बेल के लिए फिर अप्लाई कर सकते हैं. एक साल से पहले नहीं कर पाएंगे वो? जी नहीं, as
तो
per this
सुप्रीम कोर्ट
order
ने
नहीं।
और भी क्या कंडीशंस लगाई हैं जब ये बेल ग्रांट करी है?
उन्होंने कहा है कि 12 कंडीशन अप्लाई करी हैं, बट अभी जजमेंट पूरा बाहर नहीं आया है, तो वो हमारे पास अभी अवेलेबल नहीं है
It
कंडीशंस।
was a long struggle for rest of the accused. In fact, 5 have been granted bail, and 2 of them have been given time. In fact, not been granted bail. How do you react to this? What happened in the courthouse? If you could brief us.
So the 5 who have been granted bail, the Supreme Court has said that their culpability, if any, is at a lower level. And for the 2 that have, the Supreme Court has said that we are not commenting on their culpability. But because of the way it is structured, I think them in the fitness of things and judging the Constitution as well as the UAPA together, they have said that 1 more year will to examine all protected secret witnesses.
The line is patchy over there. We'll try to collect some more live visuals straight from the ground. Sabyasachi continues to stay on with me here on the broadcast. Sabyasachi, please continue. You are providing us the key details regards to the case and, of course, the hearing in the Apex Court. But first up, all right, Sabyasachi, I'll request you to please hold on for a moment again. We are again going to listen into what the advocate has to say about the case.
Custody is dehumanizing at the best of times. And these are all young people. Some were students when they were arrested. Some were going to start a job. And now we hope that they will be able to go on with their lives. So it's a massive relief for them and their families.
So what are the conditions that have been imposed by the court?
We do not know yet. It wasn't read out in open court. The judgment should be made available publicly, I think, in a couple of hours. We will know then.
Okay. Sir, all right. Thank you.
We hope in a couple of days.
Sir, has the prosecution has the prosecution defined any concrete evidence that links Umar Khalid and Sharjeel Imam to the conspiracy behind the riots?
Again, we have only heard the judgment of the Supreme Court about the conclusions. The reasoning was not read out. Until the judgment comes out in the public domain and is made available to us, we can't comment on that.
So the court has stated that both stand on a qualitatively different footing, Umar Khalid and Sharjeel Imam.
Yes.
How do you say?
That is the conclusion based on the charge sheets and the arguments made in court. And as I said, we do not know the rationale which the Supreme Court has relied on or the facts they have relied upon to reach that conclusion yet.
All right. Sir, एक single ID by.
All right, so the reasoning will be awaited. The advocate has to say that the judgment is only out till it comes out in the public domain. We'll wait to get the reasoning behind the judgment which has been taken by the Honorable Court. Sabyasachi, back to you and over to you as well.
Well, it's actually the very point that we were discussing just a few minutes back, that the Apex Court has now directed the trial court to finish the examination of all the protected witness within a year. And if does not happen, then both Sharjeel Imam and Umar Khalid can once again approach the Supreme Court. And the Supreme Court also directed the trial court that the trial should not be unnecessarily prolonged. Now, this particular point have been highlighted by both Sharjeel Imam as well as Umar Khalid, that they have been behind bars for a very prolonged time. They had presented this fact in front of the Apex Court. But the Apex Court clearly giving example of the Article 21, which is right to liberty, stating that if you are behind bars for a prolonged period under trial, that does not mean that it is equal to punishment. Now, the major point, Sakshi, why the bail application of Umar Khalid and Sharjeel Imam was rejected by the Supreme Court, because the evidences, the prosecution material which the Supreme Court has got from the Delhi police clearly shows that both Umar Khalid and Sharjeel Imam are the main conspirators. Now, several daleels were given by the side of Umar Khalid as well as Sharjeel Imam that Umar Khalid was not present in the national capital when the riots had taken place in Delhi. But the Delhi police have once again highlighted that it was done deliberately. The protest was done in a pre-planned manner, and it was done in a manner that would coincide with the visit of then US President Mr. Donald Trump, so that the international media shifts its focus to the anti-CA protest that was going on, and they wanted to use the CA protest, which they called as a peaceful protest, as a catalyst to gain international attention and to criticize the present government. And also, Sakshi, regarding the various speeches that was given by Sharjeel Imam and Umar Khalid. In fact, Sharjeel Imam went on to say that they would block the chicken neck, which clearly is an attempt to destabilize the government, is an attempt to create chaos as far as the law and order situation is concerned, because it is clearly not a protest. And that is the very point which the Delhi police have highlighted, that it was not a spontaneous protest. It was done at a pre-planned manner, and they wanted to protest across India so that similar riots can also take place in various parts of the country. So that was the main modus operandi of these people, and that is the reason why the Supreme Court today have rejected the bail application of Umar Khalid as well as Sharjeel Imam, while the court also noted that they cannot keep the other accused in the same footing as Umar Khalid or Sharjeel Imam, and that is the reason why the Apex Court have decided to grant bail to the other 5 accused, and the conditions are yet not has not been disclosed by the court. Very soon we'll get to know what are the conditions on which the bail has been granted. Sakshi.
Also, we have been given to understand that there are 12 conditions which have been cited, while the bail has been given to 5 other accused in this case, and also that the Honorable Court has made it very clear that the bail granted to them should not be considered as a dilution of the allegations against them. Mr. Dwivedi, I want to understand from you, the precedents for the investigative agencies also. How will they interpret this ruling while building the future cases in such matters?
As the honorable and learned colleague on the panel, Shraddha, said, that you see, the Supreme Court's order is the law of the land, and they'll follow this. They'll follow this, and in case, you see, what happens is that in every case, a brief is made as to how the trial progressed, and if there was any issue in the investigation, any lacuna in the investigation, that's pointed out. And it's a learning for subsequent investigations. So in case the investigating agencies feel that the case against the 5 people who have been given bail was not adequately, strongly put forth before the Honorable Court, then that would be a learning for the police and learning for us on investigation in future as to how more evidence need to be collected and presented before the Honorable Court. And again, this distinction of the main persons, the main perpetrators, the people who led the whole thing, who germinated this whole idea, that has been established, and that you have to clearly bring forth that, so that the main perpetrators, the leaders in this matter, they get the kind of justice they deserve. So it's a very important judgment for us, important judgment for the police, for the future investigations, and presenting it before the honorable courts.
Absolutely. Mr. Chadda, can you tell us what procedural safeguards still remain with the accused despite the denial or bail in this case?
Look, there is one thing very crucial which everybody should understand. The judgments of bail does not have any repercussion, does not have an effect, as always stated in the bail order also, that they will not affect the merit of the case. So, merit of the case will be judged by the evidences only. So that is to be kept in mind before proceeding further, before moving further. Now, this bail order for the 5 people who are there is also a conditional order. While seeing this order, so the detailed order will be out, I think by afternoon, then we will come to know what kind of restrictions have been imposed upon their liberty. Because whether they have to visit the police station within so many days, and various kind of restrictions, they have to surrender their passport, and so on and so forth. So 12 conditions are imposed, as Sabyasachi was telling. On the other hand, look at the beauty, which is very important to narrate here for everyone to know, that the court has also said that the trial should proceed, and those important witnesses should be examined within a period of 1 year. And if within 1 year these are not examined, or there is some stage has not come, some delays going on, then in such case, these two accused persons, Umar as well as Sharjeel Imam, both have to come back to the court for seeking the what you call bail. Now, there is a clear-cut order that for next 1 year, these two are not going to come out of the jail. There is a law, there's an order which specifically mentions, if in case the trial as desired by the Supreme Court not proceeds, then in that case these two people can come. So this is on the other end, this is a direction to the trial court also. This is a kind of direction that, look, speed up the trial so that we conclude by way of judgment, wherein if these two are guilty. We have to keep in mind the fundamental principle of criminal jurisprudence. What is that? The accused are accused. They are not, till the time they are not guilty, they are innocent. So till the time they are not proved to be guilty, they are innocent. So today, if you ask me, they are innocent. But the law's requirement is that their conduct, the previous conduct, which comes out, which is saying once again that, look, these are the conducts which are very much covered under UAPA and which is a threat to the national security. So such people should remain behind the bar.
But they have been named as the main conspirators in this case, and their bail plea has been denied by the apex court. So I want to understand the importance of court's reliance on prima facie satisfaction rather than a mini trial here.
It's not a mini trial. Prima facie in bail is, of course, the merit and the factual metrics, their conduct, what all is, the evidences before the which are produced by the prosecution are to be seen, which has been seen by the court in detail. In the previous judgment also, Supreme Court had seen that the High Court has very rightly observed out the paragraphs of those speeches, those WhatsApp messages, which clearly indicating only one fact, which clearly taking all of us to a factual metrics that yes, these are the main reason behind these riots. So that is the reason the court has taken out. It's not a mini trial and bail is never a mini trial. Bail is always a analysis where they see prima facie that, look, this is what is the factual metrics in the law. In such circumstances, whether is it okay to proceed with bail, the court will analyze it and decide that.
Okay. Sabyasachi, coming back to you, any big word on by what time can we expect the bail conditions to be out, this order to be out in the public domain so that we can analyze it better?
Well, Sakshi, it's a matter of 2 to 3 hours. The conditions will be made available to the public for analyzing the court order. And Sakshi, what is important to also understand that the court did not give a collective order today. In fact, the Supreme Court very clearly told that they have analyzed all the accused separately without giving a collective decision. Now, that is the reason why the other five accused, apart from Sharjeel Imam and Umar Khalid, they have got bail, but their bail has got around 12 conditions, and the court very clearly told that the bail which has been granted to them is not granted to weaken the case, but they have to strictly follow the conditions which has been laid down by the Supreme Court. And if they violate one of the conditions, then the trial court has the right to cancel their bail application. So Supreme Court clearly analyzing every single accused in the Delhi riot case, and that is the reason why the Supreme Court had given bail to the other 5 accused, whereas Sharjeel Imam and Umar Khalid, the Supreme Court clearly acknowledging that with the prosecution materials that has been provided to the Supreme Court, clearly shows that these two are the main conspirators behind the Delhi 22 riots.
All right, Sabyasachi, thank you so much for providing us the latest coming in straight from the courtroom. We will continue to track the big updates coming in. We will also patiently wait for the order to be out in the public domain. Thank you so much, Mr. Chadda, Mr. Dwivedi, for joining us, providing us the better answers from the experts' lens and, perspective. We have got some reactions coming in straight from the court premises. Let's take a look.
गुलफिशा फातिमा जो हैं, एंड मैं कहना चाहूँगा, शुक्रिया अदा करना चाहूँगा डॉक्टर अभिषेक मनु सिंघवी का, जिन्होंने इनको केस किया, इनको बेल दी है 5.5 साल के बाद। अब हमें उम्मीद है कि ट्रायल कोर्ट इनको जल्दी से जल्दी रिलीज़ ऑर्डर कर देगा जेल से, और गुलफिशा अपनी ज़िंदगी आगे जी पाएंगी। सुप्रीम कोर्ट ने ये भी कहा है 2 लोगों का, उमर खालिद और शर्जील इमाम की बेल खारिज करते हुए कि केस जल्दी से जल्दी चलना चाहिए, और अगर 1 साल में सारे प्रोटेक्टेड विटनेस जो होते हैं, अगर वो उनका एग्जामिनेशन ख़त्म नहीं हुआ तो 1 साल बाद उमर खालिद और शर्जील इमाम बेल के लिए फिर अप्लाई कर सकते हैं। उन्होंने कहा है कि 12 कंडीशन अप्लाई करी हैं, बट अभी जजमेंट पूरा बाहर नहीं आया है, तो वो हमारे पास अभी अवेलेबल नहीं है कंडीशन।
All right, so that was the big story of the hour, but right now we are shifting focus to another big story coming in. A stone pelting incident disrupted a religious procession in Bengaluru, leaving a young woman seriously injured. This attack took place near a temple where devotees were participating in a procession by Om Shakti Maladharis. The victim is a 21-year-old woman who sustained a head injury and was also admitted to a hospital. She is currently getting treated. According to the FIR filed by the complainant, Shashi Kumar N, the stones were allegedly thrown by 3 or 4 youth from another community. This chariot and procession participants were targeted, prompting outrage amongst the devotees. And following this attack, the participants of the procession staged a protest outside JJR Nagar police station, demanding strict action against the culprits. ACP Bharat Reddy visited the police station and is actively monitoring the investigation. The authorities are taking further steps to maintain law and order to prevent any further escalation of this matter. Police, in fact, have also registered an FIR under multiple sections, including the SC/ST Prevention of Atrocities Act, and are also investigating to identify and apprehend the individuals who are responsible. The incident has raised some severe concerns over the community's safety during public religious events in Bengaluru, highlighting the need for vigilance and preventive measures.
This is not the first time such stone pelting incidents have taken place. Incident after incident takes place, and the pelters are brazen because they know that in the name of vote bank politics, they are protected. We know that during the Ganesh Visarjan Yatra, that time also there was stone pelting, and the Home Minister said it was a small incident. Series of pelting of stone incidents have taken place across Karnataka and especially on Hindu festivals. The vote bank protection given by Congress party is the primary reason why this brazen attack continues on Hindus. And in every state ruled by Congress party at one point of time, whether it was in Rajasthan or in other parts, we have seen such attacks on Hindus. It also shows that how the law and order situation in Karnataka has completely collapsed. Congress is an anti-Hindu party, and therefore it allows such things to happen. And on the other hand, the rioters, whether they are from AIMIM, SDPI, PFI or other groups, they are given clean sheet by the Congress party in Karnataka.
And to the biggest international headline of the hour, Venezuela is entering one of the most uncertain chapters in its history after the United States carried out a dramatic military operation and captured President Nicolas Maduro, openly declaring its intention to shape the country's future. US President Donald Trump has said Washington will effectively run Venezuela until what he calls a quote-unquote safe and proper transition of power that takes place. However, on the ground, Maduro's allies remain firmly in control at the moment. Venezuela's Vice President Delcy Rodriguez has been sworn in as the interim president, rejecting US's claims and insisting that Maduro remains the country's only legitimate leader. This has set up a direct Trump versus Rodriguez standoff. While Donald Trump claims US officials are in touch with Rodriguez and that she is willing to cooperate, Rodriguez has publicly accused the US of attempting to turn Venezuela into a colony and has vowed to defend the country's sovereignty. At the heart of this entire crisis and drama lies oil, Venezuela's most valuable asset. Donald Trump has openly said that US oil companies will now move into Venezuela to fix the damaged infrastructure, will extract the oil and then sell it globally. Venezuela holds the world's largest proven oil reserves, about 303 billion barrels, though much of it is heavily crude that requires advanced refining, something US firms are well equipped to do so. But the future is far from settled from this point onwards. Venezuela's government has accused the US of trying to seize its strategic resources and destroy its political independence. Donald Trump, meanwhile, has warned that further military action remains an option if required. Globally, the reaction has been sharply divided, with Russia, China, Iran, Cuba, Colombia and Brazil condemning the US's action as a violation of sovereignty and international law. United Nations expressing deep concern over the breach of international norms. European leaders have taken a more cautious line here, rejecting Maduro's legitimacy, but on the other hand also warning against unlawful intervention. As Venezuela stands at this crossroads, the key question remains, will this lead to a genuine transition of power or push the country deeper into geopolitical confrontation, with oil, influence and sovereignty being at the center stage of a global power struggle?